Welcome to Child Abuse Awareness with Darlene J. Clark.
Hello, everyone. Welcome to another episode of Child Abuse Awareness with Darlene J. Clark. Be a part of the solution instead of part of the problem. Hello, Mr. Goodman. Good to see you. Thanks for coming in. Appreciate you coming. Hey, Jackie Glenn. Good to see you as well. Thanks for coming in, sister. Always glad to see y'all coming in. You doing good? I'm doing pretty good. Best I can be. Best I can at the moment. There's a lot going on. Just continue to pray for me. Appreciate you. Get started. I'd say hello to the people on Facebook as well. Meeting Pep Talk. This is about abuse. Abuse affects our lives in so many ways. What do we do when we are too scared to tell? When we have trusted someone and they did not help. Sometimes someone asked, "What did you do to get punished this way?" Abuse is abuse. Abuse is not punishment. Abuse is torture, crippling, and debilitating. What advice would you give others to help them through the horrendous memories? Are you there for the person, or are you part of the knife in your friend or relative's back since you may have turned a blind eye to it? Are you claiming to advocate against abuse but condemn the people who tell and share their stories? Do you want to be a part of the solution or part of the problem? Let's stand united and discuss ways in which we may help others. What ways have helped you in your healing journey? Are you in a constant battle fighting the negative forces within? Stop. Let's encourage one another. Are you an officer in the judicial system not doing your job to help the victim? This goes for judges also, attorneys. That means you're not doing your duty. Your duty is to serve and protect. How do we open the public's eyes so they can acknowledge and feel the need to help protect the children and our citizens? The children are our future. You matter. Thank you so much, Jackie. I appreciate you so much. Without further ado, I also want to reiterate that it's important that a lot of you people that supposedly Christians, come on, stick up and be a Christian and stand up for our children. Stop hurting our children. Stop coddling the people that are actually harming our children. Get them out of the church. They should not be around children at all. Okay? I did see a problem I want to touch on too. Um, I had spoke to somebody, and yeah, we had a bad childhood, but I never want to say that my abuse was worse than anybody's, okay? Just for the fact that I don't want to diminish what was done to you, okay? Your abuse or your pain, whatever happened to you, it matters, okay? I'm not going to say it did not matter. It was wrong, whatever was done to you. Hey there, Sheila. Good to see you. Thanks for coming in. This guy right here, he is a card. He's a bad guy. I want to tell y'all a couple other things as well. To the left of the screen is a thing where you can scan, and that's where you can get my book. I'm working on a new book now as well. Hello, Carlene. Good to see you too. Thank you. Hello, David. Good to see you too. So, without further ado, I want to share some different things here. Want y'all could go yourselves to this one site if you got storage or whatever, and download some things that are there, and I'll show y'all a little bit how to get into it. Right? So this is the vault.fbi.gov. Put in mind, a lot of these are redacted, okay? A lot of the files. So then I'm going to go over here to the A to Z index. Okay, I'm showing y'all how to work it, okay? It's vault.fbi.gov. Okay, here I found where there's Abner Zwillman, Abscam, Anthony Spilotru, I don't know how to pronounce it, Fast Intelligence Service, Gene Siskel, Bishop Fulton Sheen, Black Dahlia, Elizabeth Short, Edward Abbey, Bugsby Siegel. There's a lot of people in here. Clarence Smith, Dinah Shore, Dr. Samuel Shepard, Frank Sinatra. Look at all the files on him that they have. Um, Jack Sobel, Jane Addams, Joseph, I don't know how to say that name, Iopa, Marilyn Shepard, Cindy Korshak, Spyro Agnew. That just goes, list goes on and on. FBI Miami shooting, Space Shuttle Challenger, 5%ers. It's got the Atlanta child murders, ACLU, John Steinbeck. It just goes on and on, okay? So I would advise if y'all want to go and get more files and learn more about it, because there are some different articles in here that y'all might have not known about. But there's also, there's a world of information. There's even Elvis Presley's in here, and Michael Jackson's in here, and Marilyn Monroe, Al Gore. Just keep on it. So I wanted to show that to y'all, okay? Amerithrax. The list goes on and on. So I figured y'all will want to know about that. Well, y'all could go in there and maybe do some research yourself into some other things also. Hey there, Peggy. Good to see you. Yeah, that's right. Leave the kids alone. That's right. Amen to that. So now let's get on to the story on what we're having today. I think I got to. It keeps changing my screen thing to cover part of the screen up, and it gets me angry. And you notice that in this case, I'm making this bigger. The case highlights a troubling pattern seen nationwide. A convicted child predator released from prison, moving across state lines and reoffended in a new community. This guy was actually convicted for molestation of a teenager in Michigan. Okay. Now he went to Alabama, and now he's got 200 years for what he had done in Alabama. So let's go to just this. So the Gary Greenwell, here he is right here. Marshall County man sentenced to 200 years for child sexual abuse material. Marshall County man receives maximum sentence on 10 counts of possession for possession of child and sexual abuse material. Previously convicted for molestation. That's what I'm saying about Michigan. A 67-year-old Guntersville man was sentenced to 200 years in prison for possessing child sex abuse material, District Attorney Jennifer Bray announced Monday. This was published in thanks for WAFF, 48 digital staff. It was published on January the 5th, 2026, and updated from at 5:22 p.m. A 67-year-old Guntersville man was sentenced to 200 years in prison for possessing child sex abuse material, DA Jennifer Bray announced Monday. Circuit Judge Matt Elliott sentenced Gary Stephen Greenwell to 20 years on each 10 counts of possession of child sexual abuse material to be served consecutively. The sentence ensures Greenwell will spend the rest of his life in prison. Greenwell pled guilty to the charges in October 2025 in a blind plea with no sentencing agreement. Due to his prior felony conviction, the statutory range for each count was 2 to 20 years in prison. Investigation began with an internet tip. Marshall County Sheriff's Office investigator Tyron Franks received a tip in late March 2025 through the Internet Crimes Against Children Task Force. Thank you so much, Internet Crimes Against Children Task Force. Thank you, thank you. You have been so good about reporting these sickos. Thank you so much. The tip indicated an individual using an IP address associated with Greenwell's residence had uploaded child sex abuse material. During the investigation, Franks learned Greenwell had previously been convicted by a jury in Michigan for molesting a teenage boy. He was sentenced to 25 to 45 years in a Michigan prison and was paroled in 2017. So, no, he did not serve 45 years, which I think he should have, right? After his release, Greenwell relocated to Alabama and registered as a sex offender with the Marshall County Sheriff's Office. Based on the tip and Greenwell's criminal history, Franks obtained a search warrant for Greenwell's residence and electronic devices. Several devices were seized and submitted for digital forensic analysis to the Marshall County Major Crime Unit Digital Forensics Lab. District Attorney's Office investigator Barry Maddox examined the devices. Maddox testified his forensic examination revealed more than 10,000 images depicting prepubescent boys and girls being raped and sodomized across 5 devices seized from Greenwell's home. Greenwell was arrested April 1st, 2025, and has remained in the Marshall County Jail since that date. Defendant showed no remorse. What do you think about that? He is showing no remorse. At his sentencing hearing, Greenwell spoke for approximately 30 minutes, emphasizing what he described as a successful career and a life filled with opportunity. Throughout his remarks, Greenwell never accepted responsibility for his actions, nor did he acknowledge the harm caused by his crimes or the danger he poses as a sexual predator of children. Oh, he was trying to say, I guess y'all say he's trying to uplift himself, like, I'm this kind of person, I had a successful career life, I'm this, I'm that, I'm the other, and all that other kind of stuff. So that's basically saying, well, I did all this, so just let me go, right? That's the way I see it when they do this crap. Do y'all agree? If y'all agree, please put a number 1 in the chat. A real monster, yes. The volume and nature of the material found in his possession was horrifying. The sentence imposed today reflects the severity of these crimes and sends a clear message that the sexual exploitation of children will not be tolerated in Marshall County. Bray expressed gratitude to the court and law enforcement for their work on the case. We thank Judge Elliott for his commitment to protecting our community and for ensuring that offenders like Greenwell never walk among us again. Bray said, I also want to thank the Marshall County Sheriff's Office investigators, especially Investigator Taryn Franks, as well as Investigator Barry Maddox with our office, for their exceptional work on a difficult and disturbing case. Their diligence ensured that the dangerous offender will no longer have access to harm children. One thing I'm wondering about, okay? They were able to find this guy who downloaded stuff, through the internet. They were able to catch him. What about catching the people that actually had the pictures where he downloaded them from? I want to hear more about the people who had the pictures where he had got them from, okay? I want to see them arrested, okay? We want to see all these perpetrators arrested, not just somebody that had ended up downloading it, but the people that are supplying these images, right? So now we go, okay. So now we're fixing to go over. I see that y'all got one, so I'm so proud of y'all for agreeing with that. Thank you, y'all. So I got to maximize my screen again before I share the next page because it's too small for me to see. Keeps changing my setting thing, so I hate that. StreamYard, you need to do better, okay? Okay, this is actually from Michigan, the news, where he originally came from, right? So this convicted Michigan sex offender reoffends after moving south, sentenced to 200 years in Alabama prison. This is newsmediadetroit.com, okay? Convicted Michigan sex offender reoffends after moving south, sentenced to 200 years in Alabama prison. So, a convicted Michigan sex offender who was paroled and allowed to relocate to another state has now been sentenced to 200 years in prison after being caught possessing child sexual abuse material in Alabama. Okay, so now we go. Wow, he's got, according to the Marshall County DA's office, Gary Stephen Greenwell, 67, that's his age, of Guntersville, was sentenced Monday, January 5th, 2026, by Judge Matt Elliott to the maximum possible sentence after pleading guilty to 10 felony counts of possession of child sexual abuse material. Greenwell entered a blind guilty plea in October 25, meaning there was no sentencing agreement with prosecutors. Due to a prior felony conviction, the statutory sentencing range for each count was 2 to 20 years. Okay, so let's go. That prior conviction was not minor, it was also a felony. Investigators confirmed Greenwell was previously convicted by a Michigan jury for molesting a teenage boy, receiving a 25 to 45 prison year. Sorry, I'm getting too ahead of myself right here. Receiving a 25 to 45 year prison sentence in that case. Despite the seriousness of that conviction, Greenwell was paroled in 2017, later relocating to Alabama, where he registered as a sex offender as required by law. In late March 25, an investigator with the Marshall County Sheriff's Office received a tip through the Internet Crimes Against Children Task Force indicating that child sex abuse material had been uploaded from an IP address tied to Greenwell's residence. Okay, so based on the tip and Greenwell's known criminal history, investigators obtained a search warrant for his home and electronic devices. Digital forensic analysis later revealed more than 10,000 images depicting prepubescent boys and girls being raped and sodomized across 5 devices seized from Greenwell's home. Greenwell was arrested on April 1st, 25, and has remained jailed since. At sentencing, Greenwell spoke for roughly 30 minutes about his career and life accomplishments, but never accepted responsibility nor acknowledged the harm caused by his actions. The DA, Jennifer Bray, emphasized that the case underscores the danger posed when convicted sex offenders are released and allowed to relocate. So why do we allow them to relocate? That's another thing, right? Why do we allow such thing to happen? Nobody's going to know them at the new area, okay? They're just going to see another face walking in. The volume and nature of the material found in his possession is horrifying, Bray said. The sentence imposed reflects the severity of these crimes and ensures this offender will never have the opportunity to harm children again. The case highlights a troubling pattern seen nationwide. A convicted child predator released from prison, moving across state lines, and reoffended in a new community, in this case, Alabama prosecutors ensured the cycle ended permanently. Greenwell would spend the rest of his life behind bars. Now, I want you to go catch the predators and the sex offenders over there in Limestone County, the ones that's actually judges, the ones that's actually lawyers, police officers. That's just want to catch some minor people, okay? Let's get them. Let's get them, people. Let's get the governors and senators and all these people who are messing with our children. I don't care their status. I don't care whether they're uprising a good citizen in that city. But once you hurt a child, you're not a good citizen in my book, okay? You are not worthy. So let's go on to the next things. Anybody got any questions on what we've seen so far? So here is his book and picture, okay? Oops, I'm trying to get it bigger right here. Gary Greenwell, 67, male, white, Guntersville, Alabama. Book and date. The charges and bail amounts may change in court appearances, may not be current. But what's weird, they were saying, okay, the release date, I guess that was for the court, was 10/07/25. So the booking date, I guess, according to his what they said in court, was actually October the 7th, 2025 at 2 a.m. You go, woohoo, yes. So now y'all wonder, like, when y'all hear that it's child sexual abuse in the first degree, criminal sexual abuse in the second degree, criminal sexual abuse in the third degree, and whatnot. So let's touch base on this a little bit, okay? So when we look at the first degree criminal sexual conduct, okay, this is in Michigan, okay? This is where he had done the sexual abuse. First degree criminal sexual assault is the most serious criminal sexual conduct offense. It involves sexual penetration coupled with certain circumstances set out. And it's got the case, it's got the number there. Y'all can see it better. A elements offense. A person is guilty of criminal sexual conduct in the first degree if he or she engages in sexual penetration with another person and if any of the following circumstances exist. That other person is under 13 years of age. B. That other person is at least 13 but less than 16 years of age in any of the following. The actor is a member of the same household as the victim. The actor is related to the victim by blood or affinity to the fourth degree. The actor is in a position of authority over the victim and uses this authority to coerce a victim to submit. Okay, there's a lot of preachers and teachers and stuff. See? The actor is a teacher, substitute teacher, or administrator of the public school, non-public school, school district, or intermediate school district in which that person is enrolled. The actor is an employee or a contractual service provider of the public school, non-public school, school district, or intermediate school district in which that other person is enrolled, or is a volunteer who is not a student in any public school or non-public school, or is an employee of the state or of a local unit of government of the state or of the United States assigned to provide any service to that public school, non-public school, school district, or intermediate school district, and the actor uses his or her employee, contractual, or volunteer status to gain access to or to establish a relationship with that other person. The actor is an employee, contractual service provider, or volunteer of a friend care organization, or a person licensed to operate a foster family home, or foster family group home in which that other person is a resident and the sexual penetration occurs during the period of that other person's residency. I want to make sure that a lot of y'all know, yes, care is one of the places where they do um, traffic because there's individuals. CPS has been known for that. We had pinpointed that. But there are actually some good foster care family homes where people generally care and they treat the children with respect. And I want to thank everyone who is part of that, who is actually there to protect the child. See, the boy, this man, he did have to serve time in jail in Michigan under this um, CSC level one and also two, the criminal sexual conduct in the second degree. So let me go ahead and expose that. Let's see, I need to maximize my window again because I can't see what you said. Sorry about that. So monsters always manage to get jobs that involves children. They know exactly what they were doing. 100% there. Y'all agree with Jackie? Need to thank her for making that statement too. Thank you so much, Jackie. So this is MCL section 750-520C, where the criminal sexual conduct of the second degree felony, this is what it ensues. A person is guilty of criminal sexual conduct in the second degree if the person engages in sexual contact with another person and if any of the following circumstances exist. That other person is under 13. Y'all hang on because I got a couple of his court cases a little bit that he tried to do too, okay? That other person is at least 13 but less than 16 years of age in any of the following. The actor is a member of the same household as the victim. The actor is related by blood or affinity to the fourth degree to the victim. The actor is in a position of authority over the victim, and the actor uses authority to coerce the victim to submit. The actor is a teacher, substitute teacher, or administrator of the public school, non-public school, school district, or intermediate school district in which that other person is enrolled. The actor is an employee or contractual service provider of the public school, non-public school, school district, or intermediate school district in which that other person is enrolled, or is a volunteer who is not a student in any public school or non-public school or an employee in the state or of a local unit of government of the state or in the United States assigned to provide any service to that public school, non-public school, school district, or intermediate school district, and the actor uses his or her employee, contractual, or volunteer status to gain access to or to establish a relationship with that other person. Now, there was a lady that we did a story on who was sexually assaulted. She's not supposed to, that she sexually abused the students, right? But she was allowed to go back to the school, although she's not supposed to be back at that school. She is not supposed to be around other teens or nothing, okay? She is not. But they allowed her to go in there and show teenagers how to do something to some clothing and other things to decor to get ready for some kind of event. And I think that was horrendous. You don't, under any circumstances, if the law says she is not supposed to be there, do not let them in. You know what? Your school could be in dire trouble for allowing that predator back in there around all these other kids. Okay? So the actor is an employee, contractual service provider, or volunteer of a child care organization or person licensed to operate a foster family home or a foster family group home in which that other person is a resident and the sexual contact occurs during a period of that other person's residency as used in the subdivision child care organization, foster family home, and foster family group home means those terms are defined in Section 1 of 1973 PA 116. It's got a little bit of other numbers somewhere there, MCL 722.111. So sexual contact occurs under circumstances involving the commission of any other felony. The actor is aided or abetted by one or more other persons, and either of the following circumstances exists. The actor knows or has reason to know that the victim is mentally incapable, mentally incapacitated, or physically helpless. I'm sorry, that right there, no matter what you do to children, I really believe that they need to go to a level 1. We need to quit sugarcoating and dropping it down because the kid is always going to be hurt by what was done to them. They're going to be scared of other adults and everything. This is a nightmare for children, okay? When are we going to protect our children, right? So I'm sorry that it did not show what I wanted it to show that, okay? I'm sorry about that. So let's go to I appreciate you so much, Jackie. So let's go. Let's see which one of this one is. This says we're trying to get it bigger. I'm sorry. Sometimes it just wants to be menial. Sometimes it don't want me to. Okay, I got to get right here. Make it bigger this way. At the bottom right here. So this is where State of Michigan Court of Appeals. So this was where people of the state of Michigan. I think I need to minimize it a little bit. Versus Gary Stephen Greenwell. So he was one to appeal, I guess. This is considered a consolidated appeal. The appeal in docket number 188138 arises from 4 separate lower court action. This is how I knew that about his CSC1 in the level 2 and in the level 1. Okay, this is how I knew about it. Okay. This is a consolidated appeal. The appeal and docket of 4 separate lower court actions in which defendant plead nolo contendere to 4 counts of second-degree criminal sexual conduct and 1 count of first-degree criminal sexual conduct. Defendant was sentenced to 4 terms of 10 to 15 years imprisonment for the CSC, which is the criminal sexual conduct and the second-degree convictions, and 25 to 45 years imprisonment on the criminal sexual conviction and first degree. Okay, so let's go on down. He appeals as a right from the jury trial conviction and the sentences imposed. We affirm. With respect to this jury trial, defendant first argues that the first trial erred in denying his motion for directed verdict as to the CSC1 offense because there was insufficient evidence of penetration. Y'all, he actually has a video which he shows, okay? All right. Could you say he's busted himself with that, right? We review the issue de novo, considering the evidence presented by the prosecutor up to the time the motion was made in a light more favorable to the prosecution to determine whether a rational fact finder could find that the essential elements of the charged crime were proven beyond a reasonable doubt. So let's go on down to further to read more on this, right? Having reviewed the evidence considered by the jury, we find that the defendant, we find that the rational fact finder could have concluded that penetration was proven beyond a reasonable doubt. So that's sodomy, okay? Okay, why was he not also put down as sodomy, okay? Defendant recorded a videotape of the incident that was shown to the jury. See that, y'all? He recorded a video show tape. The videotape could convince a rational fact finder that at least one penetration, however slight, of the victim's anal opening had occurred. Although defendant argues that the videotape was inconclusive in light of the victim's testimony, but no penetration had occurred, the jury may well have concluded that the victim was influenced by embarrassment and a correct understanding of what constitutes penetration or other factors. A rational fact finder could have disbelieved the victim's account and concluded from the videotape evidence that the penetration element of the charged offense was satisfied. Defendant's motion was for a direct verdict of acquittal was properly denied. Woohoo! Yes, this was what happened in Michigan, everybody. Defendant also raises a number of arguments regarding a second videotape of the incident that was made by a fixed camera. All the defendant's arguments regarding the fixed videotape are premised on the notion that it was taken from a more conducive viewing angle and more clearly showed that there was no penetration that the videotape played for the jury. Why are you even having them video recording them, huh? This court has reviewed that fixed videotape and concludes that it was merely cumulative of the tape shown to the jury. The fixed videotape did not more clearly show there was no penetration or otherwise contradict the videotape that was shown to the jury. Well, so defendant claims that he was denied due process of law because the prosecutor failed to play the fixed videotape for the jury and that he was denied the effective assistance of counsel because his attorney failed to assure that the videotape would be shown. However, the record reveals that the prosecutor made the fixed videotape available to defense counsel and no objection having been raised below regarding the manner in which the prosecutor handled this issue, we do not conclude that there was any miscarriage of justice. People versus Gonzalez. With respect to the ineffective assistance claim, our review of the fixed videotape indicates that had it been presented, it may not have benefited defendant, but rather may have helped to prove his guilt. The decision not to show the fixed videotape was therefore a matter of sound trial strategy. In any event, we do not conclude that the defendant was prejudiced by the fact that the fixed videotape was not shown to the jury. Defendant next argues that the trial court improperly admitted other acts, evidence, videotape depicting a similar incidents involving other victims. We disagree. MRE 404 permits introduction of evidence of other acts as proof of motive, opportunity, intent, preparation, scheme, plan, or system in doing an act, or absence of mistake or accident. This rule permits a judge to omit other acts' evidence whenever it is relevant on a non-character theory. The videotaped incidents with the other victims were remarkably similar to that at issue in defendant's jury trial, and we conclude that it was admissible to show defendant's motive, intent, scheme, plan, or system with respect to the charged incident, which are relevant to elements of the charged crime that the prosecutor had to prove. With respect to the penetration issue, the jury may well have concluded that defendant's conduct in this remarkably similar incident was probative of his modus operandi and thus was of assistance in determining whether penetration occurred in the present case. Although defendant claims that the videotape involving other victims did not show penetration, That was a factual question for the jury to decide. So he had so he had other victims as well? Did he get charged for those cases? Yeah, I could not imagine having to be on the jury and seeing that either, I think that's horrible, right? We further conclude that there was no abuse of discretion in the trial court's determination that the probative value of the evidence was not substantially outweighed by the danger of unfair prejudice to the defendant. Finally, the court appropriately provided a limited instruction to the jury regarding the use of this evidence. Defendant contends that he is entitled to resentencing because the trial court improperly assessed 5 points under PRB 5 of the sentencing guidelines as a result of three prior misdemeanor convictions. See, he had three prior misdemeanor convictions. Why did they make a misdemeanor when you harm a child? Why? Right? However, because defendant's sentence is proportionate to the circumstances surrounding this offense and offender because the guidelines do not have the force of law, defendant does not state a cognizable claim of appeal. With respect to the plea-based convictions, defendant first raises the resentencing argument that we have just concluded in without merit under Mitchell. For the same reasons, we conclude it is without merit here. Defendant further argues that he is entitled to resentencing on the plea based on convictions because they may have been affected by the trial court's consideration of the invalid jury trial conviction imposed in docket number 188140. Because we have concluded that the conviction imposed in docket number 188140 was not invalid, this argument is without merit. Finally, defendant argues that the trial court erred in not awarding him sentence credit for the time that the prosecutor delayed in charging and arresting him on one of the offenses. What? He wanted to get away because, wow. Let's read that again. Defendant argues that the trial court erred in not awarding him sentence credit for the time that the prosecutor delayed in charging and arresting him on one of the offenses. Really? Defendant argues that the prosecutor's delay defeated the purpose of the normal concurrent sentencing policy. However, the concurrent sentence rule is simply irrelevant and has no application with regard to whether sentence credit should be awarded. Wow. Although the defendant claims that he only contested whether penetration occurred, the jury was appropriately instructed that the prosecutor had the burden of proof as to every element of the charged offense. To the extent of the defendant, who also advances a double jeopardy argument, this claim is unpreserved as it was not set forth in the statement of the issues presented. So, that's that. So, what's your take on all that, y'all? The same red flags, big time, right? I can't imagine being on that jury either. I would not want to have been there. Red flags right there, exactly. The same repeated behavior, exactly, red flags. So this guy kept doing these charges to other kids and everything. Why was it a misdemeanor beforehand, right? Why, when you're going like this and you know that he harmed these other kids prior to, why were they just misdemeanors? Do y'all wonder that as well? They were videotaped. Was it because he didn't go ahead and touch them? He just had nude? Now tell him what was done to them, and they're violated. They're doing something that kids shouldn't have to deal with, right? They said it was of sexual nature too. So why can't we just slap them all with in the first degree? Why can't we? because it's the first degree with us when we see that behavior and we deal with that behavior, right? It don't take away from what was done to the child. If we definitely want to stop a lot of these perpetrators, we need to have stricter laws and stricter penalties. Do y'all agree with that? In Alabama, they're trying to make a new law too for the death penalty. Okay, so like Georgia, I believe, has that death penalty, but then I think some person fought it or something like that with the Supreme Court, and they didn't have to face the death penalty, if I'm not mistaken. But there are some states that's going to withstand and say, well, we got that right, we got that law, and if they go and harm our kids and do these things to our kids, no, you're not going to speak for our judicial system, what we have here in this state. If they do a crime, they need to do the time, and if it's a death penalty, it's a death penalty. That's already in our legal system. Stop feeling sorry for these people that's criminalizing and harming our kids, okay? Stop feeling sorry for them. I know when it goes to a church like I had recently, and I stated on there, and I wanted to make amends with the preacher because of something he had told me, accused me of. And so I wanted to try to make amends. It's been several years, hoping he thought differently. And the wife said, maybe it's best you not to be here. Because I pinpointed, I said, well, that perpetrator that was sitting over there, the predator who's on a registered sex offender, she said, oh, all you're doing is having flashbacks from the past. I said, no, the guy was sitting there today. That is a registered sex offender. How is that saying about my past, right? When it was actually today. That person is allowed to go to church around these kids, right? So, yes, I'm sorry. I've got a problem with that, okay? I got a problem seeing a predator right there when I go to attend church. And I think we all should. Safeguarding children needs to up their game because these monsters know how to. Yeah, exactly. But it made sure there's these judges that go ahead and allow perpetrators go ahead and marry our children too. Because that's not a legal marriage in our books, okay? And then I read on, and I'm not wanting to show it right now. I just want to go ahead and talk about this. It said, well, they get a lesson if if the victim was willing. If you go and say that this child agreed to do this with me, they'll get a lesser sentence, okay? But a child is a child. A child is too afraid to really say no, right? A child, if they say no, a lot of times, like I was, I would be hit, beaten down, right? So, no, sometimes a kid cannot say no, all right? You don't go and say, well, child agreed that the child wanted it. Bull crap. It's like an old therapist I had when after I uncovered a lot of the stuff, and then I moved to Guntersville, Alabama. Seriously, I was living in Guntersville, Alabama. And the therapist said, you were not abused. You just wanted your daddy to sell you. You just wanted these sexual things to happen to you, but it never happened to you. And I was thinking, man, I wish it didn't happen. Man, wish I didn't have the scars. Wish I could have had, the body, not all the injuries that I sustained from all this. I wish that was true, but the fact is, it took so long for me to uncover it. Why would I want to cover it back up and why would I want to deny it, right? So, y'all, please, no matter what, please listen to people that's been there. I got a group at Facebook. It's called Beacon of Hope. I hope they get that started more so. I do have it started, but I want more to go in there. I want to do a support group, Beacon of Hope, and I want more people to come in there and to be supportive to the victims, whoever that shares their stories. And when they share their stories, they're not supposed to be, anybody that's in there is not supposed to go off and tell what the persons had said, okay? This is something and confidentially. Only come in if you're able to keep things confidential, all right? Don't go if you want to go in there and be supportive, be supportive. But don't go because a person's got enough trouble as it is. Don't go around and spread gossip. Don't go ahead, you know, be for the people, okay? That's how we're for them. The only rules basically that I got is, well, about the confidentially, like if somebody threatens to do self harm or hurt somebody else, then then that's going to be something else. Now, there's a perpetrator because there was one that was allowed at NASA, that was the National Association of Adult Survivors of Child Abuse. He was allowed in there, and he's a pedophile, and he's in Canada, and he tried to meet up with a 15-year-old boy, and that was a sting operation. But they were feeling sorry for him and letting him in on the group. Okay, I had trouble with that. So I fought back and I left the group. I left that site, okay? I could not condone, and I did not want to be the moderator in a group that allowed a predator to be in there. When he actually did try to reach out to some of the girls and then contact them via, um, what is that app that you use, even if you're from a different country that we use, Jackie? And he was contacting them then on there, and then actually the woman was crazy enough to go ahead and start letting her kids talk to this pedophile. Come on, people. We got to be better than that. Protect our children. Don't trust somebody just because they're in a group to talk to your kids. Don't do that. Please. Yeah, WhatsApp. That's the name of it. Yeah. So, yeah, he had contacted somebody WhatsApp, and then she went ahead and started letting him even video tape alone, have one-on-one alone with that perpetrator. I know a lot of us would not have done that. Am I right? Am I right that y'all would not have done that? I would not have done that. I would not have allowed done that to do that. They had needed another moderator. They had got rid of him for a little while, so they told me that please come back and moderate. So I went back to try to moderate, and then I was told I got to let that person back in. I said, well, I'm gone then. If y'all want him to come back in, I'm gone. And I had somebody else to help that group because we thought it's good to be able to support people who have been abused, no matter if it's sex abuse, anything. And I'm all for that. But I am not for having a pedophile in there who actually really done showed about trying to get with somebody's kids on there. And he would only call people up, that there's a call list that you could go to the NASCA website. My name and phone number was on there. Okay. And so he called everybody on that list. And if they had a kid, he kept calling that person. And since I didn't have a kid, he no longer wanted to talk to me. Okay. So it's like, okay, warning, warning, red flags, right? Red flags. So I did not understand how something like that was supposed to protect our children was allowing a perpetrator to come in there. That was allowing that. The person that owned it actually made a statement that if you say you're a part of NASCA, you're a part of NASCA. That's all it takes for you to be a part of NASCA is just say you're a part of NASCA. So you could be a predator, you could be a rapist, you could be a murderer, you could be whatever, and say you're part of that and be a part of it, be allowed to come in there to the groups. I didn't want that on my conscience. I didn't want to be responsible for none of that. My aim, if I'm a moderator, I want to make sure that everyone in the room is safe, okay? That's my goal. My thing is making sure safety is of the utmost. That voices is heard and not going to be exploited by one of these predators that comes into the room. Okay? So if y'all want to end up, I need a basis, a bunch of us to get together, talk about when it's a good time to have support meeting. If y'all got Zoom, that's where the support meetings will be on, where you'll be able to share your story and in confidence, okay? So just hit me up and let me know so that we could even maybe have a group of us chatting in um, YouTube, Facebook Messenger, and let's discuss a good time for us to be able to be there for everyone. All right. I want you to know your love and your story, no matter what. It matters. Okay. I want you to know you matter, and I want to thank each and every one of y'all for being such a blessing. Well, thank you so much, Jackie. It's called Beacon of Hope, and y'all know why it's important for the Beacon of Hope. Because now in today's society, there's not much hope out there for many people. All they see is this chaos going around. I want people to be able to come in there and let us know what's going on with them, and let's be there for one another. Be seen and heard and be valued and know that you are loved and mattered. Thank you, everyone, and may God bless.